Article 5 of the Constitution states, and I'm just going to read it so that there's no mistake.
Okay.
The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes. Now, if I heard you correctly, you were talking about the convention will be limited to a topic or certain topics. Doesn't this language fail to impose any limitations on any topic which may be raised in a constitutional convention under Article 5?
The question is, what constitutes a call? I'm a constitutional originalist, and so the question, the phrase that's there is the word call, shall call a convention. What is it? One of the factors, a call of a convention contains three things. It contains a subject matter, it contains a date, and it contains a time, a place rather. So a call will have those three elements. The topic, the lessons of history, if we've had 450 applications, and if it didn't matter what the topic was, we would have had a convention on all kinds of things. For example, right now today, if you add the plenary applications, mostly coming from the 1700s and 1800s, but there are 13 active calls for a plenary convention today. That is a convention that can consider anything. And you add them to the number of right to life amendment applications that have been exerted. You could have a convention on right to life right now today, but you can't add them. The same thing is true. You could add them together and get the 16th Amendment reversed. You could add them together and get one man, one vote reversed at the state level. There are all kinds of things if you add them together, but that's not the rule of history and that's not the rule of law. Legislative history is part of what the word call means. And we have definitively settled as a matter of legislative history. We have multiple times had the necessary number for a call if subject matter didn't matter. Now, the litigation that I did in the ERA case held, and recent court decisions have affirmed that case, that is, you can't change the rules in the middle of the stream. If you start out saying you're going to have 7 years for ratification, you got 7 years for ratification. You can't change the rules in the middle of the stream. And the same thing is true here. If you start a convention for the purposes of the three topics that we have here, you can't change the rule and add a fourth or a fifth or a ninth. You stick to the topics at hand, and that's the way it's always been, and that's the way it will be.